Government officials in Georgia are vowing to fight the Justice Department's lawsuit against the state's new voting legislation.
Our complaint alleges that recent changes to Georgia's election laws were enacted with the purpose of denying or abridging the right of Black Georgians to vote on account of their race or color in violation of Section 2 of the Voting Rights Act.
Governor Brian Kemp signed the bill into law back in March. It requires ID and shortens the time frame for mail-in voting, among other changes. Democrats say the measure will make it harder for minorities to cast their ballots. Tia Mitchell is with us now. She is a Washington correspondent for the Atlanta Journal-Constitution newspaper. Thank you so much for joining us, Tia. So we will start with the basics because there have already been other lawsuits filed against this piece of legislation. Explain the lawsuit coming out of the DOJ.
The lawsuit actually covers a lot of the same ground as the pending legal actions taken against Georgia's new election law. But what's different is this is the U.S. Department of Justice. You would have the might of the federal government and all its resources, again, challenging the need for Georgia to have changed its election laws in this way. And so, again, they're taking issue with a lot of the provisions in the new state law that make it a little bit changes deadlines for voting, changes the period for certain elections and early voting and ID and things like that. And they're saying, hey, we think this state was particularly targeting Black voters. And under the Voting Rights Act, we believe that's a violation.
So some people are going to hear some of the highlights of this legislation and, the requirement that you have specific forms of ID. Why shouldn't you show ID when you vote? Not being able to give people water or food and while they're in line waiting. How is that particularly biased? I mean, no one gets the water. It doesn't matter the color of your skin. Some people are going to see this stuff and they're going to say, I don't understand why the Department of Justice thinks that this targets minority voters, in particular Black voters. Explain the argument.
The argument is that the changes will affect everyone, but they were changes specifically made to aspects of voting laws and election laws that Black voters would be more impacted. For example, Black voters are less likely to have a driver license or official state ID. So if that becomes the main way you register to vote or request an absentee ballot, then you're disproportionately going to affect Black voters when you tinker with that aspect of the law. The same thing about waiting in line. Longer lines in Georgia, and particularly, tend to happen in Fulton County near Atlanta, in DeKalb County, which is right adjacent to Atlanta. And those are areas that have heavily Democratic voters, and also the longer lines tend to happen at precincts with predominantly Black voters. So when you say you can no longer pass out food and water to people standing in line, for example, which, in theory, again, this is not about necessarily what has happened because the law hasn't been implemented yet. But in theory, if there are long lines and you can't pass out food and water, then people might, say, I'm going to get out of line because I can't wait. I'm hungry. I'm thirsty. I'm tired of standing. And again, that could disproportionately disenfranchise or cause Black voters to not wait around and cast their ballot. So that's the argument that you're going to see the federal government making as this law goes through the process, is that the changes, if you look at the statistics, are going to affect Black voters and Democratic voters more than Republican voters based on the most recent election data.
How are governors or Georgia's governor and the Secretary of State, how are they responding to the Justice Department's lawsuit?
So they are responding, saying they're willing to fight. They have always stood behind the state law. And that's been an interesting dance for the Republican leaders in Georgia, those, the Governor Kemp, Secretary of State Raffensperger. They have both said Georgia's laws, Georgia's election in 2020 was done fairly. It was done well. That it was issue-free. Yet they've also still backed the changes backed by the Republican legislature to say, hey, we need to change the law because there are Republican voters who aren't sure if the votes were counted correctly, and they have some concerns. And so we want to change the law to make them feel secure in the election. And so that's how they've defended the new state law. And that's why they say that the Justice Department lawsuit is without merit, and they say it's, they blame Stacey Abrams, they blame Democrats, and said this is just another example of Democrats trying to reverse a decision made at the state level.
Here's the thing about the Justice Department lawsuit versus some of the other lawsuits against this piece of legislation is that if the Justice Department wins, it could have implications beyond Georgia because other states have been trying to implement similar laws, similar restrictions. So can we talk about the impact that this lawsuit may have on the rest of the country?
Yes, and that's something Attorney General Garland mentioned when he had the press conference on Friday to announce the lawsuit. He said, Georgia was the first state that passed a law that we felt was problematic, but we're watching what other states are doing. We want this lawsuit to somewhat serve as a deterrent to let states know that, hey, we're watching, and if we think you're violating the Voting Rights Act, we won't hesitate to take action. So they said there could be other lawsuits filed against other states. They're still reviewing and monitoring what's happening. But again, they felt that Georgia was the first state that passed a law that they felt unfairly targeted certain segments of voters. And so they said they wanted to take action because Attorney General Garland did make promises that protecting voting rights would be a big focus of the Department of Justice. And he said this lawsuit is proof that he took that promise seriously.
And you reported that the announcement of the lawsuit Friday marked exactly 8 years since the Supreme Court case that struck down part of the Voting Rights Act. If the Supreme Court had made a different decision and that component of the Voting Rights Act was still in place, how would it have affected this law? Would this law have been able to pass in Georgia?
The law may have passed, but it is very likely that the law would have been slowed down as far as implementation, as far as allowing it to go into effect until the federal government could review it either through a judge's review or a Department of Justice review. And it's likely that the law, even certain segments could have been, either invalidated, or the federal government might have said, hey, you need to make some tweaks. Or the federal government just might have slowed things down. As you've probably read, the law moved very quickly. It was approved in the General Assembly and signed into law the very same day. And so I think even if lawmakers had known that federal review was coming, they might have even moved a little bit slower, a little bit more deliberately, knowing what would have been coming. But for sure, the implementation of the law, which again, we haven't had a big election in Georgia since the law passed, but it's already being implemented in certain ways because there have been some smaller elections that have happened since then. More than likely, the law would still be under review if that pre-clearance measure was still in effect that was struck down 8 years ago.
Tia Mitchell, pleasure talking to you. Thank you.
Thank you.